Hi, in this video, we are going to be looking at the defense of immature age, also known as the defense of infancy. And basically, we are going to be looking at the law that provides for it and the principles generally governing this defense. And of course, as usual, I'll share with you an interesting case to illustrate this defense and the principle that was laid out in that case. Hello there, how are you? My name is Mutiawa Conrad. I'm a lawyer and a private law tutor. And basically in today's class, I'll be taking you through that defense in detail. But before we start on our class, I encourage you to subscribe to my channel in case you are watching this for the first time. Just ensure that you also turn on the notifications so that every time a video is released, this is brought to your attention. And then of course also like and share the content of this video in case you find it interesting, and also help your friends benefit. For students also interested in private law tutorial sessions, please feel free to contact us. Our numbers are down in the description box. You can always contact us and we can make an arrangement to help you in your legal career privately. Thank you very much. So let's now start right away on our defense of immature age, or also known as the defense of infancy. So basically, let's first look at what this defense basically means and what it is about. So here we are looking at a scenario where someone has been charged, okay, for committing an offense, and while before court they actually are pleading or raising the defense, saying, look, actually the person you're charging is a minor, is someone who is so young that you cannot charge them for any offense. So this defense normally works in such a scenario. So what is the position of the law? What does the law say actually on this defense? I encourage you to go and look at section 88 of the Children's Act. That section actually provides that the minimum age of criminal responsibility is 12 years. So what in essence this means is that if someone is below 12 years, they cannot actually be held criminally liable for their actions. That is the position of the law. Therefore, it follows, if that is the position, then it follows that, for example, a father cannot be held guilty of receiving, for example, stolen property, let's say from their son who is aged 12 years, because the property is not actually stolen in law. This is very important to note. I'll share with you an interesting case of Walters versus Land. It's a case reported in 53 CR APPR 94. Basically, in this case, a husband and wife were charged. Actually, both of them were charged with receiving from their son, who was actually aged 7 years, a child's tricycle, like more of a toy, knowing it to have been stolen. So they were actually charged for the offense of receiving stolen property, them knowing that actually that property was stolen from another person by their 7-year-old child and brought to the parents. So they were charged for this offense. And of course, interestingly, the principle that is important for you to pick from this case is that court held that since the child could not steal, okay, the tricycle was not stolen. So in essence, they were acquitted. Why? Because the child that actually stole, in quotations, the tricycle actually was below 12 years, or the child was below the age of criminal responsibility. The child was 7 years, and according to the position of the law, someone below 12 years is not, liable for their actions under criminal law. So the parents were also found not to have stolen, because they could not have stolen something which a child from the onset could not have stolen by themselves. So let's now proceed finally to look at the aspect of proof of age. So how is the age really of a person who raises this defense? How is it proved in court? One, of course, through medical evidence, and that can actually be through tests that are carried out on a person. So medical evidence can suffice. But also the most commonly used form of proof is what we call a birth certificate, or any other public document or government document that is able to prove the age of that person. Also, do not forget that court can also use its wisdom to actually, through observation, to look at the person. So do not forget the principle that court is the expert of all experts. So the judge can always use their wisdom to look at the person who is raising the defense, and of course conclude that actually this person is quite clearly below 12 years. So basically, that's how proof of age would suffice in a criminal trial. And those are some of the techniques that you'd use or the mechanisms to actually prove age. But you can also actually adduce or bring witnesses to testify as to the age in case all those maybe are not available. There's no medical documentation, no birth certificate, no nothing. You can actually bring witnesses who can testify to the effect that actually this person is below 12 years, especially the parents of such a child, such as the father or mother. These can always come to court to testify as to the age of the child. That would also be evidence that would be tenable before the courts of law. So basically, those are the principles governing this defense, and that was all really that we had to look at in this class. Of course, I encourage you, in case it's your first time to watch my video, please subscribe to my channel. Also turn on your notifications that every time I release videos, this is brought to your attention. And also share this video, like it in case you found the content interesting. Students interested in private law tutorial sessions, please feel free to reach out to us. We are always willing to help you. And these sessions have actually been proven to work and help so many colleagues to improve and even emerge as top of the class. Thank you very much. We meet in another class. Bye-bye.